This is the American Law Journal.
There are jerks, and then there are jerks. What if one of them is your ex-spouse in a contested divorce or custody matter? Do the rules of the game change? What are your strategies? Good evening, I'm Christopher Naughton. This is the American Law Journal, and tonight, insights and tips, both legal and psychological, when dealing with a difficult ex. Three guests, let's go ahead and meet them. Thomas Snyder is with us once again, a partner with Einhorn Harris, Ascher, Barbarito, and Frost, one of the largest, if not the largest, family law practice in the state of New Jersey. Dr. Debra Castaldo hails from the Garden State as well. She is a therapist for over 25 years, heads up the Center for Couples and Family Solutions in Englewood, New Jersey, and the author of many books on these topics, including her latest, here it is, Relationship Reboot. And returning to the scene of the crime is attorney Donald Spry, 25 plus years here on the program, so you know he's got a practice of 30 years plus, a renowned family law practitioner from the state of Pennsylvania. All right, Dr. Deb, let's start with you. And I know you don't deal with the legal end of things. Do difficult exes come up in almost every divorce situation? But again, I'm looking at some of those extreme situations as opposed to run-of-the-mill.
Not necessarily. I think if both people have really tried to work on the marriage and they both have decided this really doesn't work for us anymore, I think there can be a cordial divorce with neither one being so difficult. But I think there are three kinds of difficult exes or soon-to-be exes. I think the first one is someone who doesn't want the divorce, who's the wounded person who really wants to hurt back and be passive-aggressive. I think there's difficult exes whose marriage has been difficult, obviously, and I always say people divorce the same way they're married, so whatever issues have been there before usually continue and often get worse during the divorce process. And then I think there's the difficult ex who has had mental health issues, maybe explosive disorder, bipolar disorder, chronic acting out, or even worse, mental health conditions that are very difficult to deal with.
Yeah, good point. You guys have probably seen all three.
Yeah, you don't always know the cause, but you see the result.
And along those lines, you don't always know which is which when you start the case, which could be a big problem. You know, you may find someone who's just being difficult just because they're upset on the breakup of the marriage. On the other hand, they may have significant mental health care issues. And, you know, when do you find that out, and where are you in the stage of the case when you find that out? Sometimes, you know, a lot of these mental health care issues never get diagnosed during the course of the litigation. People just look at them and say they're a difficult ex. Well, sometimes there's a lot more to it.
The only thing that I've found that you can try to do for your client if you run into that situation is insulate them as best you can. For example, on custody situations with visitations, use emails, texts as opposed to phones, because then if there's acting out and it's in an email, you have it for a judge.
Yeah, but you know, the problem with that is, and we've talked about it on the technology segment, emails, hey, people get doctor emails. Text messages, people get doctor text messages. It's a problem always. You always have to be on your guard. You have to be appropriate, and as it was mentioned, try to cover your tracks with appropriate emails, but hey, you know, anything's possible when you get in these contentious custody cases.
You know, Dr. Deb, I've got to think often that, especially when you've got a relationship where there's a disparity in power, that happens often, and it's kind of been tamped down so that the couple can kind of get through their marriage, even though it's not a good one. And now, when the marriage is going to end, the gloves are off. So all of that repressed emotion kind of blows up, doesn't it?
Absolutely.
And that's where you see the aberrant behavior. I mean, really aberrant behavior.
Yeah, I think, you know, the grief process is difficult to go through, and as difficult as some of these divorces are, and as much as people want them, it still is a loss that people have to grieve, and sometimes they're in denial and really just acting out, you know, the frustration and the rage that has been built up over many years, sometimes, as everybody knows, 30, 40 years, where the hurt and anger has built into this tremendous rage that is now coming to the surface.
Yeah, and Don, this is of course Dr. Deb's territory, but you've got to sit across from a client, and the psychological side of your mind must be saying, okay, there's a real control freak at the other end here. Now, I know you don't try to make, you know, a moral judgment, if you will, but you've got to be able to shape or sense what your client is dealing with outside of the law.
Well, you do. I mean, there are certain predictors in some respects. If one spouse has an affair then the other spouse, that could be a reason that the other spouse is going to be very difficult in the divorce case because they're upset.
Yeah.
You run into those power issues, which can manifest itself in visitation issues with the kids. It can manifest itself with negotiations. You see it. I mean, I've been in depositions where my client had my client stand up and swear at the other lawyer, call the other lawyer names. He had to cancel the deposition, come back, get a judge's order. It's just very difficult when you don't have a judge, refereeing the situation, and you're on your own at a deposition or you're on your own at a four-way meeting trying to negotiate a divorce. Very difficult to deal with.
And Tom, I got to think that sometimes this gets into a difficult ex is also going to start playing the kind of game where, okay, if you don't dance to my tune, you're going to court. And there are some players who like to get into court or want to tell their lawyers, let's get into court. She didn't bring the kid back at 6 o'clock. She brought it back at 7 o'clock. We're going to court on this because I'm tired of it, right? You never heard that before.
I chuckle as you say that. I remember once, as a younger lawyer, I had a case. The difficult ex was my client, unfortunately. And he was upset because the child came back from camp with a wet bathing suit in the backpack that was there for 2 days. And somehow that was this issue that warranted judicial intervention. Now, the fact is, you have to put life in perspective. And when you have a client like that who's so incensed on something minor like that, you really have to be cautious in dealing with that client because they need to know that those kinds of actions may come back and really harm their case.
Mm-hmm. Go ahead, Tom.
I was going to say that what Tom was talking about, that client that wants to be in court on all of those smaller issues in the context of the case are the ones that I find typically do the worst in court, because they're so far out on a limb or they take such extreme positions that it's not something that a judge is going to look kindly upon.
Don raises a good point. I'll just comment on this briefly. It's not the difficult ex as an adverse client that's problematic as a lawyer, for a lawyer. It's when your client's the difficult ex. And trying to protect your own client from their own conduct.
Right.
And that, in my experience as a matrimonial lawyer, is probably one of the most challenging aspects of our profession.
I agree.
And I would think that people out there may think, oh, lawyers don't care if they go into court, they get paid. But I would have to think it's even diminishing emotional returns for you folks, because you don't want to go into court on every little thing. You don't care if you're getting your full rate for billable hours there. It's a pain in the neck.
And we don't like to lose. They pay me, but we still have egos.
Right.
You don't want a judge looking at you bringing those kinds of cases before them. And like Tom said, the hardest thing sometimes is to tamp your own difficult client into a circumstance where you can actually get something in front of a judge that a judge will listen to. The more you're in front of a judge on those kinds of cases, I think that the less luck you're going to have.
And Dr. Deb, I've got to think that, again, since you often deal with couples, or one of the two, in a breakup, where there's a disparity of power, sometimes that disparity is money. Now, again, these are broad brushstrokes. I know it's not true in every case, but often the angrier, more controlling party is often a male. And often that male has greater earning power than female. That's what the statistics bear out. So what happens when you know that the person you're working with, maybe the female, is dealing with a quote-unquote jerk on the other end who has a bigger war chest?
Well, I talk a lot about boundaries with both parties, hopefully, but if I'm working
That's if you get to sit with both parties, which is a sign of some evolution, but that doesn't happen all that much.
Well, you can also bring about change in the couple relationship even when they're divorcing, even just working with one. There can be changes without having both of them there. I also think it's a little bit of a red herring to think of the most angry, most vocal person as the difficult one, because you have to take into account what's going on between them. Sometimes there's a lot of power in silence and a lot of power in withholding. So I encourage people to start thinking about what are we doing between us that's difficult.
And maybe that's the best thing to do. I've heard that, if you've got one really vituperative spouse and he's sending a lot of nasty emails and why did you do this and where's my daughter and why isn't she in bed, that silence is the best retort.
Well, I think it depends. I think for some people, the silence is a way of drawing a boundary, but silence is such a big issue for women, and it really is the root of a lot of depression and anxiety in women. So I think also you have to be able to speak up and say, I'm not going to receive this anymore from you.
Got it. All right, so silence plus maybe a quick boundary line comment. Going back to the money question, you guys follow baseball. I mean, Billy Beane and the Oakland A's never had as much money as the New York Yankees. So he had to level the playing field. You've got, again, not always, but often it's a woman. Maybe she's been disabused, she has less money, and now the other guy starts pulling her into court. What do you guys have to do to start level the playing field? Do you get on the phone with opposing counsel? What do you do how do you play Billy Beane here?
Well, you can try to talk to opposing counsel, but the problem is a lot of times opposing counsel doesn't have control of their own client.
Do they tell you that?
You hear, you can tell.
Okay.
Yeah, sure. You know, in all candor, you tell the other adversary, listen, I have no. This is what this guy wants to do. This is what woman wants to do. Mm-hmm. Because quite candidly, you don't want that conduct to be a reflection of you as a professional. The reality is. But can I add this? Mm-hmm. This is what I've done to level the playing field, and with the assistance of the courts. The courts are looking to divert these cases out of the court. They're looking to send people to mediation, parenting coordinators, alternate dispute resolution. That's a great way to level the playing field.
Yeah, right, gotcha. So if they don't get in front of a Dr. Deb, at least they maybe start mediating this thing out. And at least there's kind of a neutral third party, not unlike a psychologist or a therapist. I know it's not the same thing, and I don't want to disparage you, Dr. Deb, but I mean, really, at the very least, if they can't get in front of a counselor, at least they've got a dispassionate third party who's going to, try to get them to yes.
It's probably the best thing you can do. I mean, if the recalcitrant spouse really keeps going off the wall, so to speak, you can try to get the judge to impose counsel fees, but then again, you're in court all the time, and you're not always successful on that, so then your own client ends up paying for those court proceedings. It's a scorched earth policy is what we call it, and it's very hard to combat.
Well, when you're dealing with a particularly difficult ex, can you get a court order for him or her to get counseling? What about texting or emailing with your angry ex? How's that working out for you? And let's find out why. Our psychologist says that focusing on a difficult ex may be more about you than him. That and your emails when we come back on ALJ.
This week's American Law Journal has been made possible in part by King Spry, serving its Pennsylvania clients in family law, business, personal injury, and school law for over 30 years. Einhorn Harris, a long-standing community law firm with the largest family law practice in New Jersey. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.
Divorce, custody, and the difficult ex. That's our topic tonight in the American Law Journal. The tips and the legal strategies, both psychological and legal. Tom Snyder is with us again from Einhorn Harris, Ascher, Barbarito, and Frost. A partner with that firm. He's taken cases to the New Jersey State Supreme Court. And their law firm very much involved with the family law section with the New Jersey State Bar Association. Dr. Debra Castaldo is with us for the first time from Englewood, New Jersey. She is the director of the Center for Couples and Family Solutions there in Englewood. Her latest book is Relationship Reboot, and Don Spry has been joining us for well over 20 years, and he's been in practice for longer than that. He has also taken cases to his respective state Supreme Court and is a renowned family law attorney in the Keystone State. So we've been talking about the divorce. Now we've got custody matters. Now we've got kids involved. Now all of a sudden the difficult ex, does it give the difficult ex, whether they're your client or the adversary, a moment of pause, because now it's not just the ex they're going after, they're a third party, there are kids involved here.
Well, this is a circumstance where you can get evaluations of the family unit, the kids if necessary, both parents. So you can, MMPIs and other sorts of testing can shake out if there's a real problem. Mm-hmm. See that quite often in those cases, high conflict cases.
Gotcha. Tom?
Hey, when I'm looking at a difficult custody case, I'm looking at strategy. You have to assess the adverse party. You got to read it in their mind and see what makes them tick. What are they really looking for? Are they looking just to be difficult for the sake of being difficult? Or are they they have genuine issues. You really have to get a sense of where that person's coming from. And then you need to strategize with your client how to deal with this difficult person, whether it be by emails, whether it be by being less aggressive, whether it being more quiet, as we were speaking to. You really need to tone your case to the particular facts of the adverse party. That's my assessment.
Can you make someone, quote unquote, make someone get counseling, especially when there are kids involved?
Yes.
Okay,
Pennsylvania,
so there it is, right. So in other words, and again, it's really when there are children involved that the courts are going to have their ears more open to the fact that this person needs counseling.
Yeah, I mean, Pennsylvania, I'm sure New Jersey's the same. Pennsylvania, the court is required to look out for the best interest of the child. So if there's a concern about the interrelationship of the parents with the child, you can get them evaluated. You can get home evaluations. You can get testing, all that sort of thing, and it'll come before a judge if it gets to a trial.
Dr. Deb, the impact on children.
Tremendous, obviously, but we also have to weigh the difference between being in a high conflict marriage and being in a divorce, even if that's conflictual. Either way, children suffer, and both parties suffer too, both spouses, whether they're the giver or the receiver. So I get concerned about suffering in the future too. If these patterns aren't changed, everybody's going to continue to suffer.
Let's go to some of our emails that you folks sent to us over the weeks and the days. I have been divorced for 3 years, and my ex-husband is still extremely angry and bitter towards me. He's been remarried, and I'm engaged. He continues to badger me about my fiancé being around my daughter. He demands that my fiancé doesn't attend any of my daughter's functions, such as dance recitals and music programs, or spend time with him. We live with my fiancé, and he helps take care of my daughter, who loves being around him. My ex-husband states he doesn't appreciate him trying to be a father figure to our daughter. I know this is simple jealousy, but I'm concerned because my ex-husband will go to court at the drop of a dime.
Nightmare. I'll tell you why. What I hear in that is, it's going to rise in terms of hostility, and it's not going to be the court that they have to worry about. It's going to be Division of Youth and Family Services, other child protection agencies. That's when we really start to see the stuff fly. Allegations get made of abuse and things of that nature. Investigations come in. It starts to rip that newly blended family apart, and those are tragic cases as well. False allegations are a horrible part of this process.
You have to deal with them. I mean, they may be false, but you have to go through the process to disprove them. And you're right; it's a huge stress on the new potential family unit.
Yeah, right. And Dr. Deb, how do you? Let's say you were sitting down with this woman and her fiance. What would you tell them?
Well, I would also want to have the child involved too. I think even little children are able to tell you what they want. They can speak, and for a child to get stuck and triangled right in the middle of this is really the tragedy. So I usually let the child take the lead, and if this father would be able to listen to his child and use that as the leverage to hopefully calm this situation down a little bit.
You know, when we were talking about the best interest of the child, one thing that I do find sometimes in custody cases is the parent that's acting out, the difficult parent, will try their divorce case in the custody forum. You know, it'll come out that my ex is this, is that, and a judge constantly will say, this is a custody trial. We're not interested in, you've divorced yourselves, but you're not divorcing your kids. Mm-hmm. And you can just see the venom. It's not about the kids so much as the kids are a way to hurt the ex.
Right. And of course, they're getting hurt in the process, the kids.
I think also what frustrates clients and litigants are, they go to the judge and they expect the judge to accept their story, to absorb their facts, and the reality is, judge can't really do that. They're trying to assess who's right, who's wrong, who's credible, and there's just this empty feeling for a lot of litigants when they walk out of the courtroom feeling they weren't heard, their problems weren't resolved, and that's a frustrating experience for litigants for sure.
This is an email from one of our viewers as well. I'm separated. My wife has been making custody very difficult. Now she's been dumping our child off on our parents and making me pick him up from them, usually much later now than what we had been doing. I had to call the cops because she said my son was at her parents' house, and I got there and no one was home. Cops told me that the grandparents have no right to facilitate custody swaps. Can I legally refuse to pick up my son from his grandparents? I guess you could, but who loses there?
Well, I mean, one thing that some people do is they meet at a certain place as opposed to either house. I mean, a recipe for disaster if the grandparents are on their child's side. It's just a bad situation. But the problem with these meeting in a parking lot is it's not so bad with cell phones now, but people can be late. They don't show up.
I guess my question is this: that occasionally, you get an abusive or an ex who is abusive, and they're constantly pushing the boundary, threatening you to go to court. Don't you every once in a while maybe have to go to court? I mean, it's a bit of a smackdown there. I mean, there are times where you just have to set that boundary line and say, okay, jerk, we are going to take this one to court, and we're going to give you a bit of a lesson here.
Yeah, and I'll do the flip on it. For the parent who's not getting access to their child, sometimes, you just have to go at it and be insistent and persistent and make sure the judge hears your case so that you have an opportunity to see the child. It works both ways. There's abusive spouses on both sides of the equation, which impact, you have alienation issues, which are really significant.
It's not about staying out of court. It's really about standing up and making sure you're heard.
Pushing your rights.
Right.
And choosing your battles wisely and presenting your cases in a persuasive manner. That email that you were just talking about. Listen, if I'm on the other side of that one, well, it doesn't sound like a custody case. It sounds like a power issue, a power struggle.
Right.
Where do you pick up the child? Who cares where you pick up your child?
Right.
You want to be with your child. I'll go pick up my child anywhere you tell me so I could be with my child. That's the way the answer should be. And someone not saying that, that's how you address that on an adversary claim. You point that to the judge. Judge, he's here on a motion because he's upset where he has to pick the child up. That's not about the child. That's about him.
Wow. And do they say that?
I say that.
You say it, right. Okay, that's what I thought. Dr. Deb, sometimes maybe you have to tell a client, you got to get yourself to court here. And not that you're promoting court as the solution, but isn't that, the resounding clarion call that gets it all out in the open and shows, hey, I'm not going to be messed with here?
Well, as a family therapist, that would be my last resort. My first strategy would be to try to get everybody in together, whether that's grandparents, ex-spouses, children, whoever, to try to see if there can be some healing in these relationships. Because again, the more adversarial things remain, the more suffering there is, and parents have to realize they're setting the imprint for their children's future. Whatever they see going on now is most likely what the child is going to have in their future relationships. So I'd vote for try to get them all in to mediate it in a family therapy session.
All right, here's an email from someone who's got a technology-related question. Let's see how we answer this one. My ex-husband wants to do FaceTime with our daughter every night. Some nights she doesn't want to, and some nights we have plans. When I can't do it, he harasses me through texts. He also threatens to take me to court unless I continue to allow it. There's nothing in my separation agreement that says I'm required to do this, but I do it for my daughter and because I know that I want to see her when she's with her father. Can he legally take me to court because I don't do FaceTime as much as he would like? She probably might find out you can be taken to court for anything, whether that's a good move or whether, the father in this instance gains anything from it. But yes, you certainly could be taken to court, even as something as trivial as this? Or is that not trivial? Am I assuming something?
I think that goes somewhat to what Tom said. I don't know the age of the daughter.
Right.
I mean, but if the daughter is 12, 13 years old and would say to a judge that, I love my father, but I have my own life also, and I don't want to be doing FaceTime every night, and it's, unreasonable, then it's really about the father. It's not about the child. Mm-hmm. And yes, the father could take the mother to court, but I think he'd have a tough time if it's showing that it's about him as opposed to the child.
Okay, and finally, let me just go around the horn here. Does the court ever, not just recommend, but order the family, including the exes, to get together, not just with a mediator, but with a therapist, someone like a Dr. Deb? Tom?
Yes, happens regularly. It happens less and less because, again, we're seeing more cases in Jersey going through the alternate dispute resolution and
mandatory mediation.
And it ultimately comes by agreement.
Right.
But you do see, A, judges ordering it. B, I have mixed feelings about that. And the argument is, listen, if the person's not there voluntarily and willingly, how much of a positive impact can the therapy have? You got to want to get help. You got to be willing and open to the opportunities to resolve relationships with your ex-spouse. And I'll tell you this, like clients come in on custody cases, you ask them, charge them a retainer. But I'll say this to them. Having a great or even a positive relationship with your ex-spouse, it's like having $1 million. People have no idea how wonderful it is to be able to get on the phone with your ex-spouse and be like, hey, I'm going to be 10 minutes late, and they're okay with it, as opposed to getting on the phone and saying, I'm going to be 10 minutes late, and they say, well, I'm calling the cops on you. That stinks. Do everything you can to have a good relationship. It's worth its value in gold.
And in PA, Don, go ahead.
Yeah, judges can order it. I think that they step back a little bit for what Tom said. If you're going to order somebody to counseling, it could be an oxymoron. But I also think I tell clients the best custody orders are none. That if you can arrange, because life is not Friday at 6 to Sunday at 6. You know, life is fluid, and if you can work with the other parent and not have to have custody orders, because the custody order to me is a default. If you can't work it out, you can always go to court and get a custody order, but that's not the optimum.
And Dr. Deb, last words for you.
I think therapy can be really helpful even post-divorce. We like to think of divorce as another stage of the life cycle, and I like to think of it as an opportunity for growth in relationships, because we know second marriages, the divorce rate is even higher. So right. Divorce is a great time to try to improve your relationships.
And even if that is a mandated appearance in front of you by the court.
Yeah, I think it can still be very helpful. You have to be careful that you're not trying to do couples counseling, that you're really doing co-parenting, and the family is in a different form. So you have to make sure you have those boundaries in place.
All right, it's a quick half hour. I want to thank my guest, Tom Snyder from Einhorn Harris in New Jersey, Dr. Debra Castaldo with the Center for Couples and Family Solutions in Englewood, New Jersey, and Don Spry with King, Spry, Herman, Freund, and Faul in Pennsylvania. For all of us here at the American Law Journal, thanks for joining us this week. And until next week, case closed.
This week's American Law Journal has been made possible in part by King Spry, serving its Pennsylvania clients in family law, business, personal injury, and school law for over 30 years. Einhorn Harris, a long-standing community law firm with the largest family law practice in New Jersey. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.